Call to order the meeting of the Haverford Township Zoning Hearing Board, Thursday, October 5th, 2023. Present at the front table to my far left is Jessica Vitale, a voting member.
Evening.
Next to Jessica is Ed McGargy, a voting member. To my left, Ernie Angelos, our solicitor.
Good evening.
My right, Bill Rowe, voting member. Next to Bill is Jesse Poyton, a voting member. And down to the far right, Director of Codes Enforcement. That's the way I look at it. Zoning.
Officer.
We have one decision, one continued, and one new case. The decision is going to be done last. We're going to call the continued case first, after we do the pledge. Phil, you want to lead the pledge?
This is the flag, United States of America, and to the republic which stands, one nation, under God, indivisible, liberty and justice.
All right. Our continued case is Z23-18, Robert and Regina Powers, owners of 2708 Pine Valley Lane, Ardmore, PA, DC folio number 2206 017 4800, and I won't read the rest of the description into the record unless somebody specifically requested I do so. Please come forward. How are you guys doing? So, when last we met, we asked you to bring a revised plan that showed the floodplain. The last exhibit that you had submitted was A8. Is that correct, Ernie? So why don't you identify this real quickly while you just hand it up to the board? It's exhibit A9, but what is it?
Sure. Exhibit A9 is an updated plot plan. We had a surveyor come out to our house this week and put all of the FEMA flood information and all the different heights onto this plan. So it shows where the floodplain runs through our property and where that is in relation to the patio and the proposed addition that we wanted to build.
Okay. Thank you. I have no questions. Bill?
No, but I presume some people might, but
Jesse?
So the copy that you just handed up, marked as A9, seems to, we were provided via email before the meeting a version of this which seems similar, but the version that we received has an electronic seal of a registered professional land surveyor, and this lacks that seal. So could you confirm that this is the same, prepared by the same registered land surveyor?
It is. Oh, I'm sorry. We must have. So they sent us two. They sent us a draft and they sent us the final version once I spoke with them. So the one that I sent over was the final. Sorry,
That's my fault.
printed the wrong
printed
the wrong version. But yes, it was done by a surveyor on Monday.
Do you have a hard copy of the one with the seal? Because I think it's important to have the one with the seal.
I do.
Oh, okay.
yeah. So
Can we make?
let me just ask you: is this the final one?
With the seal on it, yes, that's
So
fine. Yes.
Okay. So would it be okay to use this as the exhibit?
Yes.
For the.
Yes.
Sorry
Sorry, I didn't catch the seal not being.
I think it's important to have the official seal from a professional land
Okay.
surveyor. And can you? Is it the land surveyor here tonight?
No.
Can you confirm that Ernie, how do we qualify an expert or a engineer that's not here, perhaps?
There is an expert that's necessary to be qualified. You have a certified plan in front of you. You can consider it and give it whatever due weight the board decides it is deemed.
Okay, thanks, Ernie. And then it was based on, can you clarify what it was, it was based on what?
So this is an updated, so the plot plan was done by our builder initially, which is it's one of the exhibits that we had submitted previously. So the surveyor came out Monday to our house and did the survey of our land, came back and updated this plan with all of the flood data. I believe they used FEMA information as well and just showed where the different elevations on our land are. And just show that the patio is above the flood line, and so is our proposed addition.
And I think it's the last page of Exhibit A3, if I have that marked right.
Was the original plot plan, yeah.
As far as you're aware, it's based on the most current FEMA information?
Yes.
I don't, no other questions?
Ed?
Yes, do you know whether that this line that's been created was created based on elevations or directly copying from the FEMA map and placing on this plot plan?
That I don't know. I don't know the answer to that question.
They did do a
Where
full-
that flood line, oh, sorry, yeah.
Yeah.
Where it says 100-year FEMA floodplain, they didn't tell me where exactly that line came from.
Oh, I've seen the FEMA floodplain and it doesn't seem to match this. That's what I was trying to figure out.
They came out to the property on Monday and were there for a few hours and did all of the surveying, so I think they probably came up with the line, but again, we don't
Okay,
know.
yeah, there's two ways you can do that. You could probably base it on floodplain map and transpose that line based on the elevation, or you can copy the floodplain line off from the FAP itself. And so I guess I'm ready to support this link because the guy certified it, but it would still be based on the floodplain manager for the township confirming that. So that's okay with you, you understand?
Yep,
Okay.
thank you.
Yes?
I don't have any questions.
Do you guys have anything else you'd like to add?
No, sir.
With that, I'll ask if there's anyone present that received certified mail that wishes to testify in this case. Anyone that received regular mail? Any other residents of Haverford Township? We'll close the record on this case. And we've had you back so many times. I'm going to move that we approve this application with the following conditions: that it be completed within 1 year of this date and in accordance with the notes of testimony. Bill?
I agree.
Jesse?
I agree.
Ed?
I concur.
Jessica?
I agree.
Okay, that application is approved 5-0. Good luck.
Thank you very much.
Thank you very much.
Thank you.
Go Phils.
Yeah, the large sheet.
Ed had it. It's right there now. Right. Our next case is Z23-23, Ellis and Amy Eisen, appellants residing at 323 Barwood Road, Wynwood, PA, who challenged the zoning officer's decision to issue a building permit for the construction of a single-family dwelling to Sleep Valley Holdings LLC, owner of 319 Barwood Road, Wynwood, PA, DC Folio 220800399600, for any of all three stated: flooding concerns, workmanship concerns regarding the minimum lot area within the R4 district, 6,000 square feet, pursuant to section 182206C1. The property is R4, located in the 8th Ward.
Good evening. I'm Ellis Eisen. My wife Amy and I are the appellants in this matter. As Mr. Kane just quoted, there are three bases of our objection. Amy's going to handle two of them: the workmanship concerns and the flooding concerns. And
I need to swear you in. I need to swear you.
Of course.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And
Thank
your
you.
full name and address for the record, please?
Ellis Eisen, 323 Forwood Road, Wynwood, PA 19096.
Okay, thank you, Ellis. Now, please proceed.
Okay, as I was saying, there are three bases for us to object to the issuance of the permit by the zoning officer. Amy is going to handle two of them. I'm going to handle one. Amy's going to first talk about workmanship concerns and secondly about flooding concerns. We have some neighbors here who want to add their comments about the flooding concerns. I'll handle the final issue with respect to what we believe is insufficient area for the property under the in an R4 district.
Okay.
Okay. May I have Amy come up to the podium?
Yeah, Mr. Chairman.
Oh, I'm sorry, Fred.
Before we begin, my name is Fred Fromhold. I'm an attorney, and I represent the owner of the property in question, Sleepy Valley Holdings LLC, who is interested in this matter, and I believe is entitled to appear and participate as a party in this matter under the MPC as well as under the Haverford Township Code in support of the decision of the township to issue the building permit. in this matter. And I know that Mr. Eisen has just said there are 3 issues that he would like to address, one by him, 2 by Mrs. Eisen. In our view, the zoning board does not have any jurisdiction over those 2 items that he mentioned with respect to stormwater and trees. The third issue is, I believe, a zoning issue, and that is whether the lot in question has the minimum lot area under the zoning code. So I submit to you that that is the only matter before you over which you have jurisdiction.
Procedurally, gentlemen, because this is an appeal of a approval of the zoning officer's decision, I believe, and I wanted to get your take and consent, that it is worthy of the zoning officer to actually proceed first with a recitation of why she decided what she did, so that we have her testimony on the record, and then allow the applicant to then, I believe it's a burden shift on your end to disprove what her decision was and the facts that support that decision. That makes sense?
I would agree.
Okay.
Thank you.
Kel, you want to do this from where you're seated, or you want to come up to it's up to you. I suppose I shouldn't have joked around about your title. Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And your full name and the capacity in which you appear.
Kelly Kirk, I'm the Township Zoning Officer.
What can you tell us about this, Kel?
I can tell you that the subject property does appear to have been consolidated many, many years ago. Township records show that the property is approximately 8,200 square feet. 8,200 square feet, slightly less. I feel like I should have brought my paperwork up with me.
You can get it if you want, Kel.
But, I'm not gonna bring the whole stack, it's this high, but I'll bring what I think I need so far. So the township used to receive legal descriptions from the county anytime there was a transfer, called a real estate registration. That was until about the 80s. We have most of those still on file, with the exception of possibly a few that were lost in floods and mold and different things that we had at the other building. So the original land development files were lost. So I don't have copies of those. But the registration from August 31st of 1937 is the same legal description that exists today for each of the lots, lot number 74 and lot number 75. So that supported the survey provided by Sleepy Valley, showing that the lot size is well over 6,000 square feet.
And on that basis, you issued the permit?
Correct.
Okay.
Is there any documentation or anything you want to submit?
Sure. We can start with,
Make sure when you do, council sees copies too.
sure, of course. I did not pre-mark these because I wasn't sure what we were going to need, but we can do T1 for the real estate registration of both lot 74 and 73, which are both in this packet.
I'm sorry, that was P1?
T.
T.
T
Township.
for township.
Thank you.
In addition, I also did bring with me a copy of excerpts from the Board of Commissioners meeting from 1946, and a copy of the ordinance adopted at that meeting, which established a subdivision ordinance. Prior to that, the only required approvals were for the public improvements themselves. And obviously, 1937 predates 1946, so we can make that one T2. So no further approvals would have been needed to allow for the changing of a lot line prior to that point. I think that is just general information of background. Questions, comments, concerns?
Yes, first things first, is the township moving these T1 and T2 into the record?
Yes, please.
Any objection by either council?
And they're admitted. Do you have any other exhibits, Cal?
I do have plenty of other papers that I brought with me, but I don't know that they're necessary at this
All right,
time.
well, let's see how things
Sure.
unfold, and then
Correct.
we can decide. Very narrow scope. Any questions for Kelly, Mr. Heiser?
I filed with the zoning department a right to, what was it called? The right to,
Right to know.
what's it called?
Right to know request?
That's
Or
right.
a record
Thank you,
request?
Kelly.
Yep.
Right to know request, asking for historic documents for these two lots. I received 7 documents from Dave Berman's office, none of which was either the T1 or T2. So this is coming as a surprise to me. I haven't had a chance to look carefully. But I'll have comments in particular about the real estate registration when I have the opportunity to speak. But I just want to go on the record saying, well, I don't object. I did not receive these documents pursuant to the right to know request. Thank you.
Fred?
Thank you. And just to be clear, Kelly, prior to the enactment of the ordinance contained in T2, there was no subdivision ordinance that had been adopted or was in force in Haverford Township. Is that correct?
Correct. The prior 2 ordinances that were repealed as a result of that ordinance were simply requiring the layout and approval of public improvements, so streets, sidewalks, sewers, et cetera.
Is it fair to say then that if an owner of a tract of ground wished to subdivide that tract into lots, township approval would not have been necessary to effectuate that subdivision?
For the change of the lot lines, no. For the building on those lots, they would need to meet the zoning requirements of the district at that time. But that would be on an individual basis and not to review the actual boundary lines of the lot.
Right, so if I understand what you're saying, the lots themselves could be created, but in order to build on those lots, the lots themselves would need to conform to the dimensional requirements that were contained in the zoning ordinance for that district.
When they were being developed, yes.
Okay.
But weren't reviewed at the time for any boundary line changes.
Right. And the tract in question is located in an R4 district?
Currently, yes.
Right. And when was zoning enacted in Haverford Township?
1925.
No other questions?
Questions for Kelly? Bill?
No question.
Jesse?
No questions.
Jessica?
No questions.
Ed?
Yeah, just one question, Kelly. The issue is whether or not it's 6,000 square feet. How does T1 get us to that answer?
T1 is showing that the lot was consolidated from the, at one point in the early 30s, that it had previously, for, it seems a short period of time, was two 30-foot wide lots, and that it was consolidated by 1937 into one 60-foot wide lot.
So what is the square footage of those two combined lots then?
The full lot that exists now, that is one consolidated lot that's 60 by, I think, 157.
Is it over 6,000 square feet?
It's well, it's almost 82.
Thank you, that's what I needed to hear. Okay, thank you.
Thanks, Bill. Verizon.
Have the members of the board decided whether or not to act on Mr. Fromhold's suggestion that we can only raise the one issue rather than the three that we have considered and wish for you to consider in our appeal?
And what were the three issues again? Flooding?
Workmanship, and under the category of workmanship, based on the plans, the applicant seeks to expend to build the property $230,000, which comes out to $106 a square foot. The Philadelphia Inquirer real estate section this past Sunday said the average cost for new residential construction in the Philadelphia metropolitan area is $216 a square foot. Secondly, which is twice as much as what the plans indicate that Sleepy Valley intends to spend. And secondly, my State Farm agent, in response to my question, well, if my house burned to the ground, how much would be the full replacement value that I would be covered for? The answer I got was $272 a square foot, 2.5 times the 106 that the plans appear to show that Sleepy Valley intends to spend. Based on that,
Inference being that, what's the inference you draw from?
the inference that is that inferior materials and inferior labor will be used to construct a home which will not be consonant with the other homes in the neighborhood.
Okay, and the other issues, so workmanship?
Workmanship is one, tree removal and the effect of consequent flooding on our house and other neighbors' houses. We have neighbors here. One or more would like to speak about the effect of the removal of the trees on this lot, on their foundations and their basements. Amy would like to speak about our house, and others may want to speak as well, as I indicated.
Okay.
Yeah. So I'll add in the views of my personal views as zoning hearing board member, but the quality construction, the aesthetics of construction, they're not within our purview. Okay, so we hear people come in and make those claims all the time. Rarely do we hear complaints after a project's actually completed. People come in and they presume that a developer is not going to build to the standards of the neighborhood, but it's not really within our purview. We're looking at the zoning code. If there's provisions of the zoning code that you think are not being complied with for this project, that's certainly within our purview. But, and the other point on flooding, I would have you watched some of the zoning hearing board decisions in the past on TV or whatever, because we always condition, or nearly always condition, approvals for variances. Now, this is a different type of case.
Right.
That the project does not adversely affect neighbors from water runoff resulting from their project. Most developers will come in and they will, as part of their application, they will at least endeavor to reduce runoff as a result of their project from what it was before, rather than exacerbate it.
May I respond to
Sure.
that in two respects? Number one, a grading application was filed after I forwarded a copy of our ISA certified arborist report talking about the possibility of flooding. The grading permit application. The second question asks the applicant if there are any other neighbors who may be affected by the grading, and that question was left blank by Sleepy Valley. That's number one. Number two, fortuitously, I found out that Sleepy Valley would be appearing or would have its tree removal application reviewed by the Shade Tree Commission. And Mr. Davitt from the Shade Tree Commission, the chairman, was good enough to allow me to have a hearing. The township solicitor was consulted about whether or not they could consider the possibility of flooding on a neighboring property. He said that they could not consider it, notwithstanding my pointing out provisions of the Haverford Code, which indicated that the effect of flooding should be considered on when trees are removed. So while the members of the Shade Tree Commission were good enough to hear me out, they said they didn't have jurisdiction to make a decision based on the effect of flooding. That leaves me with you.
Well, I think the shade,
Just, twofold. One, I think as it relates to the workmanship, that's a BCO issue. I think it's definitely within both the Uniform Construction Code and likely any other construction code requirements of the township, subject to the review by the building code officer throughout construction. As it relates, and it's certainly not a particular zoning issue, there's nothing in our zoning code as it relates to workmanship or product of a development or a home or a structure of any sort. As it relates to the flooding, you'd indicated that a grading permit was issued. Kelly, so was that done by the engineer?
Correct, yes.
Is there any appeal of the engineer's determination that the permit was sufficient?
Not that I was aware of, but I probably wasn't notified.
Okay.
Although I was an interested party that the zoning officer heard from 15 months ago.
So stormwater management is always an issue. It's always relevant in terms of a concern that residents have before the zoning hearing board. But it is a township governed ordinance and law. The stormwater management is not dictated, set forth, or governed by this particular body, although we do take it into consideration because anytime somebody's doing development, that's always a concern. And this board has always, as Vice Chairman Rhodes had indicated, that if this were a variance application, the board would typically make a condition that, any stormwater management comply fully with the ordinances of the township and not impact any neighbors. That is not technically what is in front of us this evening. It is an appeal of a granting of a permit by the zoning officer. And I would believe that both those topics are not particularly within the purview of the jurisdiction of this body. However, the third one absolutely is within the jurisdiction as to whether or not this lot sufficiently meets or doesn't meet the minimum lot size for development within that particular area.
So has the zoning hearing board as a body decided not to hear the two of the three issues that we seek to raise?
Well, I would make the recommendation based on my understanding of the law and actually the motion made by council that those two particular issues are not within the jurisdiction of this particular body.
Well, we're going to follow advice of our council and not take those two items into consideration due to the uniqueness of this hearing in particular.
I don't think the board has the authority to make any decision one way or the other on them, honestly.
And that's why. Nothing we would do would be binding.
In that case, I'll proceed to the third, but I want to thank the neighbors for coming out. I know
Mr.
some of
Eisen,
you were
if-
going
If I
to.
might interrupt you, since you just got these, would you like a few minutes to read through them? I mean, we can take.
I don't need that, but I would like to make one comment based on what I saw. May I do that now?
Sure, or proceed as you wish.
Okay.
I wanted to give you
First
an
of all,
opportunity to-
Mr. Kane, I want to thank the neighbors for coming out. I know some of them wanted to testify about the effect of removal of trees.
They can certainly make public comment. Nobody's saying that they can't make public comment. We're just indicating, and any public comment's relevant to review. I'm just saying that we don't have the authority necessarily to overrule a decision simply based on workmanship concerns and or flooding concerns.
So any comments it would make would be in vain with respect to reversal of the issuance of the permit
It's possible.
On those bases.
Yeah, on those bases alone.
on those bases? Well, I thank you for coming out. I know one or more of you were interested in speaking, and you're certainly welcome to stay and hear the rest of the matter, and appreciate it. I do want to make one comment about Ms. Kirk's T1, I guess it is. That's a real estate registration dated September 1, 1937, based on the date of acquiring title, August 31, 1937. I did see the two deeds. The deeds indeed were dated that date, and they were registered with Haverford Township the next day. Registration of a deed does not set the parameters of a zoning lot. Obviously, I shouldn't say obviously, but a 24-hour period between when a deed is recorded and when the township would receive it and have a registration stamp poised is not sufficient time. I think we would all agree for a review to be made whether or not there should be any consolidation. And by the way, these two documents say nothing about consolidation as far as I saw. Maybe the zoning officer can correct me, but her comments with respect to T1 in particular talked about consolidation. There were two deeds, nothing about consolidating the two of them, so I would vigorously disagree that these two lots have been consolidated. I want to make a particular...
Are you going to submit evidence? Are you going to submit drawings or evidence or other documents into the record that you'll want to support that assertion?
All the documents that are among my exhibits are, from my perspective, sufficient to make my point.
Okay,
but-
you'll need to submit them into the record. This is a
You
formal
want me
step.
to, the appeal,
The application,
Incorporated.
the application itself is not technically in the record yet. So,
would you like me to move to have it?
yes, and
Okay.
what we might be able to do is, and I think that's what the Mr.
I see.
Vice Chairman
I
said.
move to have the 40-page packet which accompanies my appeal moved into the record.
Is there anything in particular with that, that you want to point out to through your recitation of your position?
Yes.
That maybe we can identify to make it easier for the record? So if we're talking about one particular deed in that property, we may be able to identify that as A1 so that there's reference in the record
Yes.
to review. Okay.
The zoning officer was kind enough to accept 6 pages worth of documents, and they're on the screen. I'll try to identify, well, you have a screen here. I'll try to identify where they are in the packet as well, but I'll refer to them as the exhibits. Thank you, Kelly.
Go ahead.
The permit we're appealing is for building a house on the property described in folio number 220800396000. I want to use the term 396 to distinguish it from 395, which is adjacent to 396, but is not the subject of the permit. 396 has an area of 4,788 square feet, which is too small for a residence in an R4 zone with a minimum of 6,000 square feet. As you will see, it will appear on the plans that were submitted by Sleepy Valley that the house straddles the boundary between 396 and 395. In our township, permits are issued only for properties identified by folio number. Since the plans anticipate construction on both 396 and 395, and the permit is only for 396, that alone would appear to be a basis for you to reverse issuance. 395 was not the subject of the permit. 396 was. Any questions about that?
Just that, this is the license inspection, and this is the document, the permit that was issued that you're appealing.
Does it say 396, Mr. Angelos?
Let's take a look, 'cause I took it out of your packet, and I want to make sure so I can identify it.
Understood. Thank you, Mr. Angelos. This is the L&I permit, certificate of occupancy and/or compliance, permit number 2023-103723. Date was August 11th, 2023. Folio number 22080039600. Nothing about 395.
Okay, and we're gonna, since that is the permit that you're appealing, why don't we mark that A1 if that's okay?
That's fine.
Which is A1?
I'm sorry, Fred?
Which is A1?
The permit.
It's the permit.
Permit, this one. That's all right.
And just for the record, I guess that is the 10th, the 11th page of your 40-page.
What are you referring to, Mr. Rhodes?
Okay, you're going to do them split.
I'm gonna try and mark them individually.
Okay.
Yeah, as you go through,
Okay.
to kind of make it easier.
Thank you. I know we have to,
Yeah.
we have to accommodate the stenographer, et cetera. Ready for me?
Yeah, please proceed.
Yeah.
Okay. The first slide on the screen is Exhibit C9. If you're looking at your packets, it's the third page from the end. It's an excerpt of a June 1930 survey and map of Ben Carroll prepared by Milton Yerkes,
What year was this?
1930.
1930.
Milton Yerkes, Yerkes.
And your marking scheme is going to be A for the applicant. So this has Exhibit C9 typed at the top of it, but in keeping that marking scheme, this will be A2.
A2, thank you.
Is this one page? Because there are three in my packet.
There are three. The third from the end is the relevant one, Mr. Poynton. Okay? It shows in the towards the bottom right side, you'll see parcels 74 and 73. Yeah, I think it does show up on the screen. Both of those were purchased by Sleepy Valley from Sylvia Boynal in June of 2022. Later that year, 3 months later, Sleepy Valley sold only parcel 73. That's the parcel in which the house at 315 Farwood exists. Sleepy Valley sold that to the Tates. So that's parcel 73. Our house is on the other side. If you see the 75, that's where the Eisens lived for the last 40 years. On the survey and map, you'll see a line dividing parcel 74 into two more or less equally sized subparcels. And the words iron pin were written in on the survey and map in small print, both at the top of that dividing line and at the bottom of the top of the dividing line. Those iron pins were actually hammered into the ground, and approximately 6 months ago, Joe Celia and Chuck Faulkner and Amy and I were out there and we found them.
I'm sorry, excuse me.
On Exhibit A2, since the 7 and the 4 are on either side of the line, I want to refer to the subparcel next to our property, next to lot 75, as the 7 subparcel, and the one next to the Tate's property on 73 as the 4 subparcel. The dimensions of the 7 subparcel are 30.08 feet by 159.6 feet, which are the same as folio 396. I'll repeat myself. The only property the subject of the permit that was issued by the zoning officer. A little history, and you'll see this in the deeds if you're inclined to take a look at them, which are exhibits in the middle of our packet. 1930, Ben and Ida Carroll conveyed to the Hayneses a newly constructed lot, a newly constructed house, that's the 315 Forward Road house, on a lot and a half. That lot and a half was parcel 73 and the 4 parcel. The 7 subparcel was at that point, I'll call it an orphan. 5 years later, the Hayneses purchased the orphan, made it part of their family. So the Hayneses then owned both subparcels of 74 and parcel 73. In 1937, as the zoning officer has testified, there was another deed, 2 deeds in fact, that was in December 1937, where the Hayneses sold both the 73 parcel and both subparcels of 74 to a family known as the Wilsons. Well, that was December 30, that was sometime in December 1937. A few weeks before, if you remember Mr. Yerkes, the surveyor, they invited Mr. Yerkes to come out and redraw the lines. So
I'm going to object to that. Saying what somebody was invited to do in 1937. I don't object to the documents themselves, but the characterization of who was out there and who might have said what, I do object.
the 1937, thank you, Ms. Fromhill. The 1937 deeds incorporate the revised meets and bounds
So we
and
have,
refer to the December resurvey by Mr. Yerkes. So it's of record in the deeds.
we have an objection. Zoning hearing boards and matters before them do not comply with the strict rules of evidence. However, the objection is noted, and the board is able to grant whatever deference and authority it seems appropriate for the testimony presented, noting the objection.
The revised survey by Mr. Yerkes a few weeks before the 2 deeds, cut off 30 feet of the 4 subparcel from the parcel 73 and added it to the 7 subparcel. So, and that's how it's remained today. And that's presumably the basis for the zoning officer's issuance of the permit, believing that there's been consolidation. The zoning law in Pennsylvania does not make determinations of lot size, zoning parcel by deeds, by meets and bounds, by surveys. It makes it according to any public records that exist. The public record that the zoning officer has provided does not prove that is consolidated. Again, she used the word consolidation. Consolidation does not appear in either T1 or T2. I suggest that those parcels have not been consolidated and cannot be consolidated. The land development and subdivision law section 160 of the Township Code provides the basis for land development. Among the definitions, it says, and this is section 160.2 of chapter 160, subdivision and land development. Land development is any of the following activities: the improvement of one lot or 2 or more contiguous lots, tracts, or parcels of land for any purpose involving a group of 2 or more residential or non-residential buildings, whether proposed initially or cumulatively, or a single non-residential building on a lot or lots regardless of the number of occupants or tenure. So Sleepy Valley, for consolidation purposes, has one lot or two or more, it has two or more contiguous lots. However, the purpose for which they're put is limited to a group of two or more residential buildings. This lot, even if you look, these two sublots together total approximately 9,600 square feet. I'm not sure if that's what the zoning officer said, but that's the approximate amount. As you know, in an R4 district, you need at least 6,000 square feet area. For Sleepy Valley to consolidate the two laws, the two subparcels, it would need 12,000 square feet to build two houses. Mr. Rhodes, you're looking at me quizzically.
Yeah, I'm just trying to understand the math. So the applicant's proposing to build two houses on
No,
this
no.
lot?
No,
Okay,
no. If
so-
you were-
So that's purely speculative by
I
you.
believe that the two parcels are not consolidated, but that if Sleepy Valley wanted to consolidate them, they would not be able to.
So,
because-
but Sleepy Hollow could by right build a house on each of those two lots?
No, it could
currently?
not.
So that you're
They're
thinking
each
that now they're.
4,800 square feet,
So let
Mr.
me
Rhodes.
finish. So your proposal or belief is that these are undevelopable lots?
They could not build improvements as required in an R4 zone.
So short of a variance by us?
Short of a
no,
variance.
There's no by right development on either of these lots?
No improvements
So
could be
you
built.
don't recognize grandfathered property, non-conforming properties?
If the two properties, the two subparcels have been consolidated, that's one thing. They were never consolidated. The public records that I received from the right to know law, thank you, Ms. Zoning Officer, did not include anything. If that isn't accurate, then I have to object to the fact that the township did not comply with the right to know law.
Okay,
That
that's
doesn't
not in
concern
our
you.
purview. Enforcement, the right to know law has statutory enforcement provisions. You're welcome to go after the township for that. That's not tonight. That's not in front of us, right?
I agree.
Okay.
I agree. Let me make my next point, if I may. The next exhibit, which is C2, is the plan submitted by Sleepy Valley.
Hold on 1 second, Mr. Marson.
It should be in the middle of of the packet that we put together.
2 pages, right?
One page.
Just 1 page, okay.
Do you have it?
Yeah, but I think it actually, is it, the one I think I have has C1 written on it, I believe you said C2.
Okay.
Oh, so that's the correct one? Okay, it's C1, okay.
Can I use that?
Yeah, you can do that.
So what has typed at the top, Exhibit C1, will be your Exhibit A3, okay?
Okay. If I can ask you to look at the screen, I have revised that document by drawing in red ink a horizontal line across the page. I believe that line is the boundary between, on one hand, as you see, written in by me, folio 396, the 7 subparcel, and below the line, folio 395, the 4 subparcel. I repeat, the application, the building permit was issued only for 396. I don't see how plans, well, I suggest to you that plans for a different folio number, in this case 395, cannot be the basis for issuing a building permit. And on that basis alone, as I think I said at the beginning, the building permit, I believe, should be reversed.
So from what you've said so far, it just seems like if this application had mentioned the other parcel, in case it had not been, then the application would have been valid?
If Sleepy Valley, if I may respond, if
Yeah.
Sleepy Valley had been the owner of 395, I would agree with you. Sleepy Valley is not the owner of 395. Let me go 2 exhibits ahead. This is Exhibit C3 from the packet. Exhibit C3 is the tax folio for the 395 parcel. You'll see I underlined 395 in the upper left-hand corner.
Go ahead, Artie, make it A4.
Yeah, we'll make the document written Exhibit C3 at the top, which appears to be the property record card from the Board of Assessment Office for Delaware County.
A4.
A4. Got it. I mentioned it was for the property 315 Fairwood, if I didn't.
Right. And this is a two-page exhibit, Mr. Angelos.
Right.
This tax folio information shows Mrs. Tate, Colleen Tate, as the owner of 395. If you go to the next page, you'll see at the top the recent history of ownership. The Tates purchased the property 395 on September 7th, 2022 for a price of $55,000. Sleepy Valley purchased it approximately 2 or 3 months before, on June 22nd, 2022, for $679,000.
And you said 55,000, but I'm reading 550,000.
I beg your pardon, thank you, $550,000. It struck me as odd that there'd be such a differential. I represented Mrs. Voynal at the closing when she sold to Sleepy Valley, and the agreement of sale and all the closing documents referred to the purchase price as $700,000. The allocation of $679,000 to 395, the parcel that the Tates purchased, which is 97% of the $700,000, created an artificial tax loss that Sleepy Valley was able to use, and that's fine.
I object to that.
And that one, I'm not even going to ask Ernie, I'm going to sustain, and that's,
The allocation between the $679,000 and the $21,000 did not occur at the time of closing. It was done elsewhere, presumably at the behest of Sleepy Valley.
I object to that again. I mean, we're getting involved.
I mean, that's a characterization of things,
Okay.
which there's
I mean,
no evidence, so I agree with you.
Let me go to what I believe is the relevant part of this.
Right.
395, as indicated in the tax folio, is owned by the Tates. 395, if the plans are to be believed, is the parcel on which Sleepy Valley intends to build. My conclusion is that the Tates are paying Sleepy Valley's taxes.
And from that, if that were true,
And if that were true, I go back to my basic premise, that the zoning officer cannot issue a building permit for 396 when the plans say that the house is to be built on 396 and 395. That's basically my case, members of the board.
thanks.
We're going to take 5 minutes. We're going to take 5 minutes. Yes. We'll resume the meeting of the Haverford Township Zoning Hearing Board. Mr. Eisen.
Excuse us.
I have set out the bases for our belief that the building permit should be reversed. I understand that Sleepy Valley's council wants to, as intervener, make some comments as well. I only ask for the opportunity for a short rebuttal when he's completed his presentation.
Fair enough.
Thank you.
Thank you, Ross. Good evening again. I would like to expedite the case that we're presenting by marking certain exhibits as, I can call them S for Sleepy Valley, S1 through whatever we're doing here. And the first two that I would like to introduce are S1 and S2. And S1, and I will hand this to the board. I've got multiple copies of this, and it is a 1927 Yerkes plan for the Ben L. Carroll property. And you have seen this in its 1930 version, which will be
This is S1?
this is S1. And I had pre-marked these, I didn't know which one to be using, which may have already been introduced.
If you need a copy to give him, we could share it. Okay.
Did I give you a copy?
Not yet.
There you go.
Thanks, Fred.
So this is the original development plan dated September 29, 1927, made by M.R. Yerkes, C.E. And I've highlighted on that plan Lot 74 and Lot 73, and those numbers you will see referenced on the subsequent plan, as well as in the deeds that we're going to be marking and introducing. S2 is the map of property of Ben L. Carroll made by Milton R. Yerkes, C.E., dated June 11, 1930. And this is the same exhibit as A2, which Mr. Eisen had shown you. He had shown you a blow-up of a portion of this plan, and this is the larger view that shows additional lots. But it does show as Mr. Eisen had shown, if you look at lot 73, that is in the same shape. There is a Z between 73 and 74, which can mean a couple of different things, either common ownership or there's been some consolidation of those lots. I don't know that that's relevant here in this case, because what will be relevant, I believe, is the 1930s. But it does show on lot 74, the line that goes down the middle of 74 that divides 74 into what Mr. Eisen had called subparcels for 1974. And I think in a nutshell, this case really comes down to, are those two subparcels still independent parcels today, or do they exist as a consolidated parcel? Mr. Eisen's position is that they remain two subparcels. Our position is that they have been consolidated, and I'll go through that. And I think actually T1 that Ms. Kirk had introduced really showed that to be the case in 1937 by virtue of the deed from that date. The next exhibit is the same as Exhibit A3, and this will be S3. And this is the plan that was submitted in connection with the permit application that is the subject of this appeal. A larger colored copy of and it does indicate that the area of the lot that is shown, the combined subparcels, if you will, is 8,196 square feet, which is substantially in excess of the minimum lot area. It also shows that the lot width of 60 feet is in excess of the
minimum lot width of 50 feet as required by the code. I believe it also shows that all of the other bulk requirements of the zoning ordinance are met. Next is S4, and this is an excerpt of the Haverford Township zoning map. And on S4 is the map that shows Farwood Road, and there's a red dot on that map. Shows the parcel in question, which is lot 74.
And just to be clear, S4 is actually a blown-up version of the township zoning map, specifically referencing the subject parcel.
Yeah, that's correct.
It's not a complete.
No, it isn't. Thank you. It's just a section that includes the property in question. And now what I would like to do is go through deeds. S5 is going to be the last deed of record that relates to this application. And this is a deed dated August 16, 2022, from Sleepy Valley Holdings LLC to Colleen Tate and Ayinda Tate, and that is recorded in deed book 6857, page 4958. And it describes lot number 73, which is the lot that immediately adjoins lot 74, on which a house was built and existed as of the time of this conveyance.
Thanks.
And I think as the chairman noted, that shows a consideration of $550,000 for that lot. This is lot 73. The next is S6, and this is a deed from Sylvia Voynow by Samuel R. Voynow, her agent, grantor to Sleepy Valley Holdings LLC, grantee with a consideration of $700,000. And as you will see in this exhibit, there is a conveyance of both lot 73, on which the house is located, and lot 74, the lot that is the subject of this.
It's S6, correct?
S6. Now, I Mr. Eisen had indicated that he was the attorney involved in this transaction, and the deed that was delivered by his client to Sleepy Valley Holdings contains a legal description of the property that is being conveyed, and that is attached to Schedule A. And Schedule A,
You're still talking about Exhibit S6?
that's correct.
Okay, thank you.
Exhibit A describes two separate parcels. It says, all that certain lot or piece of ground with buildings and improvements thereon. And it goes through a courses and distances description of that lot, and then says being lot 73, known as 315 Farwood Road. And of course, there's only one address here, one mailing address where the house is located, and it is noted there below that description. There is then following it a second description of another lot, and it says, all that certain lot or piece of ground. Note that it doesn't say there are any buildings or improvements thereon erected, because there aren't. This is lot 74. And then it describes what is lot 74 that was shown on the 1927 plan and the 1930 plan that we had talked about earlier on those two exhibits. And it contains that courses and distances description, and describes lot 74 just as it was shown, with full 60 feet of width, not with the two subparcels, not described as two subparcels. It's described as a single lot, a single parcel on the deed that Mr. Eisen's client tendered to Sleepy Valley Holdings. And then it contains the recital. Next is S7. And S7 is a package of deeds. And the deeds that are in S7 are highlighted on the cover sheet. These are deeds that were collected for us by the shot group, the surveyor that provided a site survey of the lot number 74, and they went through the chain of title to look at all of the deeds going back. So if you look at the deed into Sleepy Valley Holdings, the recital in that deed is Deed Book 2191, page 1176, which is the first deed here. Now, I'm not going to go through all of these deeds individually, but there is a commonality to all of them going back to Deed Book 1040, page 388, and 1040, 386. That I will talk about that commonality, and then I'll talk about those 37 deeds in Deed Book 1040. What is the same on all of these deeds is that they all describe the property in the identical fashion as it was described in the deed to Sleepy Valley Holdings. They describe lot 73, with all that certain lot or piece of ground with buildings and improvements thereon erected. And it describes lot 74 as all that certain lot or piece of ground. What I've done is I've highlighted that on all of the deeds going back so that you can go back in the chain. I've also highlighted the recital that is contained in each deed, so it's easy enough to go back to the preceding deed. But the order in which the deeds are listed in the packet follows the order in which they are listed on the cover sheet there which is prepared by the Schott Group dated July 5, 2022. When you then go back and you flip to the deeds that are in the very back, there are two deeds from 1937, and they are both deed book 1040. One is at page 386, and the second deed that immediately followed is at page 388. The deed in deed book 386 was a conveyance of the lot that is the subject of this appeal, lot 74. And I have highlighted there those relevant dimensions, the 60 feet to a point and the 60 and 16/100 feet to an iron pin, just so that you can tie it in to it being the same description as had been set forth in all of the subsequent deeds. But in this deed, there's a recital that says, being lot 74 on the aforesaid plan, and it says, being as respects a portion of the premises above described, and it cites to a deed book 889-116, and then it says, being as respects to the remaining portion of the premises described. So it was in this deed that the, quote, subparcels that Mr. Eisen had talked about were consolidated in a single legal description. And that was in August of 1937. The deed that is deed book 1040, page 388, is lot number 73. That hasn't changed at all from its original creation back in on that Carroll plan in 1927 and 1930. That has remained described in the identical fashion right up and through the conveyance that was made to the Tates from Sleepy Valley Holdings. So what does the case come down to? It really comes down to, are these two subparcels two separate, distinct, non-conforming 30-foot wide parcels, or are they a single consolidated parcel? And up until subdivision came into being in Haverford Township in 1946, that was T2, the T2 exhibit. Lots were created by deeds, by a deed description, often referring to a plat or a plan that sometimes was of record, sometimes was only of record because it was referred to in the deed. So that's how subdivision was done. So this lot, number 74, has the same subdivision integrity as all the other lots in the Carroll development and all the other lots in the township and that were created prior to the enactment of the subdivision ordinance in 1946. Lots that were previously created by deed description didn't have to come back at a later date after subdivision code was enacted or subdivision ordinance was enacted in Haverford Township for some type of new subdivision or confirmation that they were a subdivided lot. They continued as a subdivided lot. Mr. Eisen's appeal has, I think, indicated that there's a little glitch in the assessment portfolio, that while these lots were in common ownership through all these years, it would appear that from the time that they did appear as subparcels, that the assessment went on one of the subparcels and included the other subparcel together with lot number 73, and that simply has perpetuated up until the current time when that assessment information in the county records will need to be corrected. We didn't go and try to correct it before we had the hearing, but the lot that is now owned by the Tates is lot number 73. The folio information would indicate that it includes the subparcel that's immediately adjacent to that, but that's the county information, the county assessment information. As long as these properties were owned by the same owner, it really didn't make any difference. All of the land and the buildings were being assessed and taxed, and it was all in the same owner. But now that that lot is, is conveyed to a different owner, that folio number needs to be corrected, and it's the intent of our client to do those administrative tasks. And what happened on the permit that was issued, by referring to that folio number, it didn't correct that at that point, because that hasn't been corrected by the county, and that will need to be corrected. But the lot 74 exists. It has existed as a lot that is fully formed, fully approved by virtue of the conveyance that is in deed book 1040, page 386. So that is our case, and I believe that the permit was properly issued for the plan that was shown for lot number 74. That's 60 feet in width. Thank you.
Cal, did you want to speak again about?
I did, well, just wanted to clarify at least one thing. In the subdivision and land development ordinance, chapter 160, there was reference to a definition under 160-2 for land development, but not the defined term of subdivision, which is the division or redivision of a lot, tract, or parcel of land by any means into two or more lots, tracts, parcels, or other divisions of land, including changes in existing lot lines for the purpose, whether immediate or in the future, of lease, transfer of ownership, or building or lot development. It does go on after that, but specifically that if for a reason it was determined that these lots were still separate and hadn't been merged in 1937, which I don't agree with, the property owner or the developer could absolutely go before the planning commission to do a lot consolidation to change the lot line and effectively make it a very much buildable lot if it were found to be two separate lots. The other thing, in A4, where we were looking at the, A4 was the Delaware County tax assessment information for 315 Farwood. There's a description of a property that's 114 by 157 irregular. 157.6 does appear on A2, but I don't see if we're saying that my determination should be solely based on the numbers from the tax assessor's office, where there's a dimension of 114 anywhere within those two parcels, either cumulatively or by itself. And then furthermore, if you look at the tax map attached to that parcel, they have a drawing tool or measuring tool, which isn't going to get you to 100% accuracy. But if you were to measure out, the ground lot in question, it measures to 60 feet. So all of those things in addition, to the legal descriptions of records, also, show that there's discrepancies with the tax assessor's office that, clearly do need to be cleared up, but don't show me that there's two 30-foot lots.
And Kelly, are the Delaware County assessment records typically determinative, or do people look to the deeds?
If I'm looking for a general idea of a lot size and it's a very rectangular lot, sure.
That's not what I was-
Otherwise, if it says irregular at the end of it, I'm absolutely looking at the deed because I'm missing multiple numbers.
If I could just add one thing based on that. If you look at the deed for lot number 73 on which the house is located, this was the last deed in the package that I gave you.
S7, are you talking about?
Yeah, I think that, yeah, for lot 73. If you look at the recital there, it says being part of the same premises. So actually, at one point, that was a larger, I think it included the piece to the opposite side, going towards, the intersection, that, away from lot number 74. So when you go back and you look at those predecessor deeds, it had actually included a larger piece at one point. So I now that I'm thinking of that, I will correct what I had said about lot 73. I think this is where the house is located. At one point, I think it included property going in the direction opposite from lot number 74. But it was reconstituted as lot 73 in this 1937 deed. So it went back to lot 73 as lot 73 was shown on the 27 plan and the 1930 plan. But that really isn't relevant to the analysis here because
Yeah.
we're focused.
But
I
just-
don't want to get lost on lot 73
Right,
because we're talking about.
just to be clear though, so you're thinking, Fred, that lots 72, 3, and 4 may have been unified at one point, even though in 1927 they were plotted out and planned to be separate.
And the answer
right?
is, I think the correct answer on that is no, that they were never unified as a single lot.
But between 1927 and 1937, the lot line between lots 73 and 74 seemed to have moved. At one point, lot 73 got bigger?
No, it didn't.
No?
It-
Okay.
And I guess we need to be careful about what we mean when we're talking about lot 74. Okay, lot 74 was at one point divided into the quote subparcels that Mr. Eisen referred to. You had two 30-foot side-by-side parcels. But then they were consolidated in 1937 in that deed that refers to lot number 74, okay, that's being a part of and being a part of. I could have taken this further back to deeds beyond that. I didn't think that was relevant because what really I think this board needs to know is at what point was lot 74 constituted. We start getting into handwritten deeds that are very difficult to read and so forth, to go back and we could do that. And in fact, we have some of those deeds, and I have a witness who would have been prepared, is prepared to go and talk about that. But I don't think that is, it may be interesting information, but I don't think it's relevant information.
Look, I agree. I think the Carroll map sets a basis for which you can analyze the apparent movement or possible movement of a lot line here. But I think it's your position that by 1937, whatever may have gone on, whatever pins may have been put in the ground in the middle of lot 74,
Right.
They were either not removed accidentally, but 74 was constituted as your client currently identifies it.
That's right. And that's what was conveyed to our client as in the deed to Sleepy Valley Holdings.
Did you get a title policy when
Yes.
your client acquired it?
Yes.
So we're going to give the applicant time to rebut. The board, reason why we recessed is we've been thinking about all of the things before us, and it's rare that you actually have two attorneys before us for this type of opportunity to arise. What the board would like, and what we would ask the court reporter to do, is to turn around a transcript relatively quickly for you both. And we would like briefs, either findings of fact and conclusions of law, to be submitted to the board. We would hold the matter open for those briefs to be submitted. I would, recommend maybe within 15 days of getting a copy of the transcript. And then the board would reschedule this for 30 days out. When's our November? This is the beginning one, so it would be the beginning of November, right?
Yeah.
November 2nd.
Can I ask you one question, though? You said hold the record open, so after we do public testimony.
Well, yeah, it would be, technically the record would be closed, but we would hold the matter, is what I meant.
Yeah.
For the submission of the briefs. We
Any
would-
decision would be held in advance.
Correct.
For the submission of briefs.
Findings of law, conclusions of law, and then, from both parties, we would review that, and then on the November 2nd, the board would render a decision on the matter. Thinking that it would give us time frame for both parties to submit within 15 days, and then an additional roughly approximate 15 days for the board to meet with me and review, and then be prepared to render a decision on the November 2nd timeframe. And I wanted to make sure, did that seem okay with council? I think it would be relevant and helpful to this board if that were the case.
We don't know when the transcripts will be available, so
15 days from the date of the transcript is what I was looking at. And we would look to have the court reporter turn that around quickly,
Okay.
and both counsel be able to contact her and go through her services and obtain copies of the transcript.
and you're suggesting we can do this so that on November 2nd, we'll be back here, or by November
Yes.
2nd, you'll render a
No,
decision?
the hope is that by November 2nd, we would be in a position to render a decision.
And when would you like the conclusions of law and
I-
findings of fact within 15 days after?
Yeah,
the
15
transcript?
days of the date you guys obtain.
Okay.
Preferably, it would be 15 days from today, but
I
that's
understand.
not
I understand.
really sufficient to you guys, depending upon how quickly she gets it. Fair enough. Okay.
So any idea of when you might have it? I'm just thinking
Yeah.
that we may be pushing close
And
to,
that might be the case. I want to work through with council appropriate time frame to get it.
we would like to have the period such that you would be able to render your decision. If that would shorten the 15 days, that would be okay. Because I think although we don't have the record, can't cite to it, we have a pretty good idea of what our exhibits are here, and we can go ahead in the meantime, get our briefs.
And that's fair too.
So, Ernie, our meetings are the 2nd and the 16th of
Okay.
November, so at least they're both pretty much in the first half of the month.
They are. The only reason why I was holding it to the 2nd was technically under the MPC, we have to, reschedule meetings every 45 days. So I was looking to kind of shorten that. Obviously, we can extend that if the parties agree to waive that, applicable period.
I think we'd like to get this, get your decision as soon as you reasonably can do it.
Okay. All right, so with that,
Shorten the time frame to 10 days.
yeah, why don't we try and do it 10 days then? Briefs within 10 days. And then we'll look to get it scheduled quickly as possible, most likely on the 2nd. That seem fair?
Yes.
Okay, all right. With that, I certainly want to give council the ability to rebut. But I appreciate you guys' cooperation with that. I think it'd be helpful for the board.
Mr. Fromhold and the zoning officer have referred to the 1937 deed registration, which I believe would have accompanied the 1937 deed as a consolidation. Lot line changes are not a consolidation. They never were, they never are, they never will be. Today, that's the province of the Planning Commission or you folks to approve consolidations or subdivisions. The 1930 deed, the handwritten one that Mr. Vromholt referred to, had certain lot lines. 1937, as I suggested before, the surveyor came out and changed them. That qualifies for consolidation? I would think not.
Now
The
or
rear
then?
change, I'm sorry,
Now or then?
then as well. That would allow a Wild West show for anybody to change lot lines through a private contractor
We
in
almost
order to
had that
qualify.
problem. Didn't we almost have that problem essentially, that because subdivisions and reverse subdivisions didn't have to go through township approval, that it was a Wild West, that notwithstanding that we had a zoning code that had area and bulk requirements, that here we had a conforming lot between 1927 and 1937 that was converted by deed by two owners into two non-conforming lots? That's the Wild West, right? I hear you. I think we were in a Wild West situation in that interim period between the adoption of the zoning code of 1925 and the requirement that subdivisions and reverse subdivisions, consolidations, whatever you want to call it. I'm not going to get hung up on semantics.
Right.
But in that interim period, it certainly led to the opportunities for private owners to wreak havoc on the zoning code, because they could take a conforming lot like we saw here that potentially was converted into two non-conforming lots.
I hear what you're saying. I don't think that the 1937 deed and the deed registration created a zoning lot merely by the redrawing of lot lines.
Right, and that's why I think the briefings will be so important, because I
Right.
think you are making a conclusion of law that we obviously will
Right.
look for the basis part.
Last thought. A zoning lot is defined by the Commonwealth Court of Pennsylvania in two recent cases, and you'll see this in my research, as a public record, not a private record, because public records are generally trustworthy, and private records, such as surveys, such as deed descriptions, represent self-interest of the party that's preparing them. So the public record here that is extant is not, in my belief, the 1937 deed registration. That was merely a recitation of what was in the deed prepared by the surveyor who came out a second time. The 2023 tax folio, and remember, folio numbers count before this zoning board and to the zoning officer. And we have we have folio number 396. The 2023 tax assessment shows dimensions of 30 by 159.6, 4,788 square feet. That, in my belief, is the one public record that determines the zoning lot, and therefore the zoning requires 6,000 feet, is not met in this case.
Well, there you go. You've defined the issue for the two briefs, right?
May I make one final comment? And it's going to be very brief. The deed that was tendered by Mr. Eisen's client to Sleepy Valley Holdings described two lots. One was Lot 74, with its complete, full description as it existed on that 27 plan, the 30 plan, the 37 deed, and ever since. Thank you.
Mr. Fromfield, just one quick thing. I don't think you have moved your exhibits into the record.
Just
wanted to make sure you did that.
Thank you. Yeah, I know different boards have different
Yep,
rules on that.
S1 through
Yeah,
S7.
thank you, yes.
Any
Thank you.
objection?
No.
Okay, third
Thank you
minute.
all.
Thank you.
Did he move as exhibits?
Yes, he did.
I didn't have any objection. Surprised. All right. Let Arlene get their call. You ready, Arlie? All right. With that, I'm going to ask if there's anyone present that received certified mail that wants to testify before the board tonight. Anyone that received regular mail? Any other residents of Haverford Township? With that, this case is continued to our November 2nd hearing.
But for purposes of the record
The
is
sole
closed.
purpose of receiving the briefs and rendering a decision that night. Off the record, Jeff? All right, we'll resume the meeting of the Haverford Township Zoning Hearing Board of Thursday, October 5th, 2023. We have one decision, case Z23-05, DMG Elite Properties LLC, owners of 8 Campbell Avenue, Havertown, PA, DC folio number 223000224000. And I won't read the rest of the description into the record unless someone specifically requests that I do so. Are you prepared to vote, Jessica?
I am.
Ed?
Yes.
Bill?
Yes.
Jesse?
Yes.
And so am I. Jesse, do you want to take that decision?
Yes, Mr. Chairman, with regards to case Z23-05, I would vote to approve the following variances. 182-802D1 to allow a change in nonconforming use from a restaurant to a 3-story mixed-use building with an office, showroom, and storage on the first floor and 4 apartments above in expanded 3rd floors. I would vote to approve variance for 182-707B to allow 14 off-street parking spaces where 18 are required. I would vote to approve variance for 182-208C1D to allow the building coverage currently non-conforming at 43.9% to be increased to 47.5% where 40% is required. I would vote to approve the variance for 182-208C1E to allow the front yard setback currently at 20 feet, not including a 9-foot wide, quote, fire escape, end quote, stairway, to be replaced with a slightly less than 9-foot wide handicapped accessibility ramp to a first floor entrance where a 20-foot setback is required. I would vote to approve variance for 182-208C1F to allow the side yard setback adjacent to the neighbor's driveway currently at 5.24 feet for the entire length of the building and a portion of the existing building that is 3 stories high to remain at 5.24 feet only on the first floor where 7-foot minimum setback is required. I would vote to approve variance for 182-208C1G to allow the rear yard setback adjacent to the Cheese Club currently at 3.86 feet to remain at 3.86 feet where a 25-foot minimum setback is required, but this approval of the variance shall only be for the first floor only. I would vote to approve a variance for 182-208C1I to allow the impervious surface area currently at 84.6% to be reduced to 83.4%, where 65% maximum impervious surface area is required. I would vote to approve the variance for 182-802 to allow the bulk square footage of the building to be increased from its current 5,873 square feet by an additional 5,102 square feet, or as amended by the variance above, thereby allowing applicant to extend the existing non-conforming footprint to a full 3 stories. I would vote to deny variance for 182-208C to allow portions of the proposed new building to be reconstructed and other portions of the building to be expanded to full 3 stories above the currently non-conforming footprint of the existing buildings. And that was covered in the 25-foot, the rear yard setback variance. And I would do that with the following conditions. That all work shall be done in conformance with all applicable building codes. The project shall be completed within 1 year and in accordance with the notes of testimony, except those notes which are inconsistent with the variances granted hereby.
Bill?
I agree.
Jessica?
I agree.
Ed?
I'm opposed.
And I agree. So that application is approved with those conditions, 4-1.
We have to do minutes.
Yep.
Okay. Administrative matters, Jessica, minutes.
I would like to make a motion to approve the minutes from June 20th, August 17th, and September 21st.
I'll second that motion.
Okay, all in favor?
Aye.
Aye.
I would abstain as I was not at that meeting in person.
But there's three meetings,
Oh.
meeting minutes that you moved.
Oh, it's the last one, for the last meeting. I'm sorry, I'm abstaining from.
So you're in favor?
Yep.
Except you're abstaining just on the minutes of
Exactly.
the last hearing.
Sorry.
Jesse?
Aye.
I agree as well. Okay, any other matters?
You have 90 days to appeal to the Court of Common Pleas. You'd have to file a notice of appeal to the court.
Any other administrative matters?
You will get a copy as a party. The township will send you a copy of the notice, and then also a written decision. Findings, facts, and conclusions law will be permitted, or excuse me, will be permitted within 45 days of today's date. You have 30 days. 30 days. Correct. Correct.
Then we are adjourned.